Firing the fatal shots, the accused must have foreseen, and therefore did foresee, that whoever was behind the toilet door might die, but reconciled himself to that event occurring and gambled with that person's life. This constituted dolus eventualis on his part, and the identity of his victim is irrelevant to his guilt. As a final counter to the state's case, it was argued that although the accused had not acted in private or so-called self-defense, there had in fact been no attack upon him that he had acted to ward off. He had genuinely but erroneously believed that his life was in danger when he fired the fatal shots. As opposed to what is commonly known as self-defense, this is so-called putative private or self-defense. The principles relevant to these two defences were authoritatively dealt with by this court in de Oliveira and were explained by Smallberger J.A. as follows, I quote, "The test for private defence is objective. Would a reasonable man in the position of the accused have acted in the same way? In putative private defence, it is not lawfulness that is in issue, but culpability. If an accused honestly believes his life or property to be in danger, but objectively viewed they are not, the defensive steps he takes cannot constitute private defence. If in these circumstances he kills someone, his conduct is unlawful. His erroneous belief that his life or property was in danger may well, depending upon the precise circumstances, exclude dolus, in which case liability for the person's death based on intention will also be excluded. At worst for him, he can then be convicted of culpable homicide. On appeal, the unlawfulness of the appellant's conduct was not in issue. Accordingly, the only issue was whether the state had proved beyond all reasonable doubt that the appellant subjectively had the necessary intent to commit the crimes of which he was convicted. In other words, that he did not entertain an honest belief that he was entitled to act in private defence. The immediate difficulty that I have with the accused's reliance upon putative private defence is that when he testified, he stated that he had not intended to shoot the person whom he felt was an intruder. This immediately placed himself beyond the ambit of the defence, although, as I've said, his evidence is so contradictory that one does just not know his true explanation for firing the weapon. His counsel argued that it had to be inferred that he must have viewed whoever was in the toilet as a danger. But as was pointed out in de Oliveira, the defence of putative private defence implies rational but mistaken thought. Even if the accused believed there was someone else in the toilet, his expressed fear that such a person was a danger to his life was not the product of any rational thought. The person concerned was behind a door, and although the accused stated that he had heard a noise which he thought might be caused by the door being opened, it did not open. Thus, not only did he not know who was behind the door, he did not know whether that person in fact constituted any threat to him. In these circumstances, although he may have been anxious, it is inconceivable that a rational person could have believed that he was entitled to fire at this person with a heavy caliber firearm without even taking that most elementary precaution of firing a warning shot, which the accused said he elected not to fire as he thought the ricochet might harm him. This constituted prima facie proof that the accused did not entertain an honest and genuine belief that he was acting lawfully, which was in no way disturbed by his vacillating and untruthful evidence in regard to his state of mind when he fired his weapon. In order to disturb the natural inference that a person intends the probable consequences of his actions, the accused was required to establish at least a factual foundation for his alleged genuine belief of an imminent attack upon him. This the accused did not do. Consequently, although frightened, the accused armed himself to shoot if there was someone in the bathroom. And when there was, he did. In doing so, he must have foreseen, and therefore did foresee, that the person he was firing at behind the door might be fatally injured. Yet he fired without having a rational or genuine fear that his life was in danger. The defence of putative private or self-defence cannot be sustained, and there is no bar to a finding that he acted with dolus eventualis in courting the death of the deceased. In the result, on count 1 in the indictment, the accused ought to have been found guilty of murder on the basis that he had fired the fatal shots with criminal intent in the form of dolus eventualis. As a result of the errors of law referred to, and on a proper appraisal of the facts, he ought to have been convicted not of culpable homicide on that count, but of murder. In the interest of justice, the conviction and the sentence imposed in respect thereof must be set aside and the conviction substituted with a conviction of the correct offence. Of course, the accused has now served a portion of the sentence imposed upon him in respect of the lesser offence of culpable homicide. But the issue of what would be an appropriate sentence was not debated before this court, quite properly, particularly in the light of the Constitutional Court's judgments in Nobolisa and Bogarts, as the matter must be sent back to the trial court for sentence to be imposed afresh. In doing so, obviously, whatever punishment has already been served by the accused in respect of the incorrect conviction of culpable homicide will be taken into account. Before closing, it is necessary to make a final comment. The trial was conducted in the glare of international attention and the focus of television cameras, which must have added to the inherently heavy rigours that are brought to bear upon trial courts in conducting lengthy and complicated trials. The trial judge conducted the hearing with a degree of dignity and patience that is a credit to the judiciary of this country. The fact that this court has determined that certain mistakes were made should not be seen as an adverse comment upon her competence and ability. The fact is that different judges reach different conclusions, and in the light of an appeal structure, those of the appellate court prevail. But the fact that the appeal has succeeded is not to be regarded as a slight upon the trial judge, who is to be congratulated for the manner in which he conducted the proceedings. I conclude with the following order being to be made. 1. The first two questions of law reserved are answered in favour of the Director of Public Prosecutions. 2. The accused's conviction and sentence on count 1 are set aside and replaced with the following. Guilty of murder, with the accused having had criminal intent in the form of dolus eventualis. 3. The matter is referred back to the trial court to consider an appropriate sentence afresh in the light of the comments in this judgment.
Well, that was Judge Eric Leach of the Supreme Court of Appeal in Bloemfontein making that judgment for the state against Oscar Pistorius. Brenda, the question I want to go to quickly, Judge Leach there spoke about putative private defense. Could you explain that for us?
Putative private defense, or so-called private defense, when you think erroneously that your life is in danger when in fact it is not.
The other thing for me, the issues raised by the defense in their affidavit for leave to appeal,
yes.
For leave to appeal the SCA ruling to the Constitutional Court, why were these not raised at the Supreme Court of Appeal?
Well, they couldn't really raise those at the Supreme Court of Appeal, and they didn't cross-appeal. This is the other problem. And if we look at judgments, even from the Supreme Court of Appeal with the Methodist priest, etc., the Supreme Court, the Constitutional Court has repeatedly warned litigants, even in the Barnard versus SABC matter, that you cannot raise new issues at the Supreme Court of Appeal or at the level of the Constitutional Court. Now, that is why any such application that brings in new and novel issues is doomed to fail.
Even in the also in their affidavit is that they contend that the Supreme Court of Appeal will respect impermissibly reconsider the factual finding by the trial court, and they genuinely believe and honestly believe that he genuinely believes that his life was in danger.
No, the Supreme Court of Appeal, we must remember that the whole issue of reservation of questions of law, the court doesn't just look at the question of law in vacuo. And at the beginning of that appeal, Justice Leach said that very clearly, that it's the question of law and the facts which underpin. You cannot just say, this is the reserved question of law, we are looking at dolus eventualis, but we are not going to look. It's not just a purely factual finding that they are interrogating. Hence, the state couldn't succeed in having the third reserved question of law upheld, because the court said, but this is a factual dispute. If we must now take into consideration the different versions, then we are entering the fray of factual disputes rather than a question of law.
Well, when we come back, we will look at what should have happened initially after the Supreme Court of Appeal made that judgment in favor of the state. If you'd like to join us, you can call us on 714-5497 or 5490, to tweet us at Rights Recourse or email us on rightsrecourse@sabc.co.za. Stay with us.
News from the SABC's online news services. On our website, breaking news and in-depth coverage of everything from business, sports to politics and lifestyle. Catch the top news clips and watch live streaming of major news events on the SABC News YouTube channel whenever. Stay connected on the SABC News Facebook page and have your say on news that matters to you. And for the latest headlines and live updates from our reporters, follow us on Twitter. SABC Digital News, anytime, anywhere.
And it makes then provision that bail be granted. It's subject to three things. The one is the application for leave to appeal to the Constitutional Court. The second event is that if that application is successful, the appeal to the Constitutional Court, and if unsuccessful, then the matter must come back to the trial court for a consideration of the imposition of sentence on the present conviction.
Having considered all the submissions that were made by both counsel, I make the following order. The case is postponed to the 18th of April 2016. The applicant is released on bail of 10,000 rand and the amount of bail to be paid on or before the 11th of December 2015 before 16 hours at the office of the registrar of this court.
Welcome back, and that was Judge Aubrey Dwaba giving the order there after the defense's application. Brenda, what I wanted to know, after the Supreme Court of Appeal set aside the culpable homicide conviction and to murder, what should have happened afterwards?
The registrar of the Supreme Court of Appeal was under an obligation to formally inform the attorneys of Oscar Pistorius, the registrar at the North Gauteng High Court, and Oscar ought to have been either placed under arrest or brought before court on the very day. We must remember that this is the Supreme Court of Appeal. On the other hand, the National Prosecuting Authority, or the state, is a creature of statute. What they then did, if you look at the affidavit in support of bail pending appeal, Oscar Pistorius sets out that Gerrie Nel agreed that between Friday, or whenever the negotiations were held, and his appearance in court on Tuesday, his sentence he would be under the same conditions as his correctional supervision sentence. Now, how does the Supreme Court of Appeal set aside a conviction, expressly set aside a sentence, and then the state, which doesn't have the power, they don't have power to grant any indulgences, how do they then go ahead and make a deal with the defense that, no, don't worry, Oscar, these conditions are going to apply? Look at Cindy Mangele's case, the Flabba Habedi murder trial. Immediately she was convicted, she spent the night in police cells because Section 58 of the Criminal Procedure Act says bail will remain until conviction. Immediately conviction, when it's after conviction but prior to sentencing, it is in the discretion of the court whether or not to extend bail. And the one consideration is normally, is there a possibility that a non-custodial sentence will be imposed for this? The following day, that lady had to appear in court and she was then released on 15,000 Rand bail.
The question I want, now that the case is going to the Constitutional Court,
yes,
it is not often that the Constitutional Court hears cases, criminal cases.
Well, since the Alan Busak decision, where they actually clarified what is a constitutional matter or a matter relating relevant to a constitutional matter, not many criminal cases have gone that route, but quite a couple of them have actually gone that route. And then we've got Rule 18 and Rule 19, one where you apply for leave to appeal from the SCA, or direct access, which is the route that Oscar Pistorius is taking, where they'll file papers within 15 days.
Many analysts believe that they are in unison in saying that Oscar better have a strong case going to this Constitutional Court.
Well, yes, he does have to, because remember, the Constitutional Court, once they receive the application for leave to appeal, may actually just dismiss it in writing, or they might say, well, this is important, let's hear the defense on this, but that doesn't mean that the appeal will succeed anyway.
I read the affidavit,
Yes,
which is a very lengthy document, and it would seem to me that the thrust of Pretorius' appeal was that the Supreme Court of Appeal had not limited its finding to legal principles of dolus eventualis,
yes,
to a question of law, but that it also considered the facts in reaching the conclusion of murder.
Well, they were under an obligation to do so. So after they had decided that these the first two are indeed questions of law, they were under an obligation to take into account the factual basis of those two reserved questions of law.
The other thing that concerns, somebody says, some analysts are saying, there is no way you can consider questions of law without looking at the facts.
You can't. You can't. When those questions have been reserved and they've agreed that these are indeed legal questions. Remember, at the commencement of the appeal proceedings, Gerinel stood up and said there are two obstacles or hurdles which the state has to cross. The first one being the Siakui judgment, and they crossed that hurdle. And the second one was whether indeed these are questions of law. And the SCA agreed that the first two were indeed questions of law.
The issues for me really in this case are, I would want to say, I think Judge Leach did allude to that this was a public case, and many people are saying Oscar can raise the issue of unfair treatment due to the glare of television cameras. Well,
it's something I mentioned in an article in De Rebus, but it's too late. The horse has bolted from the proverbial stable. If Oscar Pistorius, and I tend to agree that to a great extent his rights were violated, evidence, witnesses were watching the trial, etc., 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 so there was a dilution. However, he ought to have appealed against the culpable homicide conviction as well as the sentence on culpable homicide. So if he had appealed then with the basis, on the basis that his right to a fair trial had been violated, then indeed he could take it all the way up to the Constitutional Court. He cannot wait now for the blow that has come from the SCA to then decide, okay, what do I rush to now? Let me quickly go and say I had a trial by media and therefore my trial wasn't fair. Why did he accept his culpable homicide conviction and his 2761I imprisonment?
It would seem to be going into the last bit of court, the last court appearance of Oscar Pistorius before Judge Aubrey Lidoba.
Yes.
It seems to me that the public out there is quite divided on this issue.
I always say there are three camps, right? There are those who are pro-Oscar Pistorius, and we saw the same sentiments with Hansi Cronier's matter. You know, in Xhosa they say inimba, inamamenemen. So there's the camp that is pro-Oscar Pistorius, including a few journalists as well. Then there is the camp that wants Oscar down no matter what. And then there are the people in the middle who are objectively saying what are the legal principles that basically affect that. But the majority of people are saying Judge Masipa was incorrect.
Well, if you'd like to join us in today's discussion, you can call us on 011 714 5497 or 5498 or tweet us at Rights Recourse. Or you can email us at rightsandrecourse@sabc.co.za. Stay with us.
As stories are broken around the world, SABC makes sure you do not miss out. As the stories unfold throughout the day, News at 8 updates all newsworthy stories worldwide. Globally, we are there. Locally, we leave no story untold. Make a date with News at 8 every Saturday and Sunday on SABC News, Africa's news leader.
Welcome back, and before we continue as we discuss the Oscar Pistorius appeal to the Constitutional Court, let us take this call from Anonymous. Good afternoon and welcome to Rights and Recourse. Hello, good afternoon. No, I thought I had a call. Like we don't have but Brenda, I see in the affidavit of Oscar Pistorius, they say, if the Constitutional Court grants leave to appeal on the grounds that the matter raises an arguable point of law of general public importance, which ought to be considered by the court, I think they're trying to push the Constitutional Court to accept this appeal.
Which point of law now? And, you know, of interest and of importance, those are two totally different considerations. So it's not just that the whole world is curious and, you know, we've been entertained and glued to our television screens, but it is more about whether it is in the interests of justice to grant him leave to appeal to the Constitutional Court.
Let's take this call from Mona from Johannesburg. Mona, good afternoon and welcome to Rights and Recourse.
Good afternoon.
Yes, Mona, what is your
can
call?
I speak?
Yes, go ahead.
Okay. My opinion of Oscar. Can you hear me?
Yes, we can hear you. Go ahead.
Yeah, my opinion of Oscar, in South Africa, there was no law that sticks up for women in this country anymore, and it's about time that these murderers should be put away. He killed a lovely woman. All men that rape and kill any woman must go and rot in jail. And I'm a 73-year-old pensioner, and I'm sorry to say all this is not nice anymore. They rape, they come out after 3 months. Now we women will stand together with the ANC and we will fight this battle. Oscar must rot in jail. And also the Flatta, the same case. That lady killed that man, so she must sit. I agree with that fully. Thank you very much.
Thank you, Lorna. That's no explanation there. Let's take another call from Tato from Limpopo. Hello, Tato. There's no caller. I thought Tato was there. So okay. It is very clear. This issue of Oscar Pistorius seems to be happening on last time when the murder occurred. Can I say murder? When the murder occurred, it took place on Valentine's Day, and during the 16 days of activism, Oscar is appealing the sentence.
Yes, and that's when the judgment came out as well.
This is when the judgment came out as well. That's rather strange. The issue that many people are saying, we spoke earlier about the camps, the very many camps. Yes. I was actually surprised to see on social media the support Oscar has overseas.
He has a lot of support. You know, some of them argue, you know, and everyone is entitled to their opinion. And there are counter arguments and there are arguments, and sometimes it descends into wars really where people insult one another. And they always turn it around and say, well, the crime levels in your country are that high. What did you expect Oscar Pistorius to do? And I mean, you get people defending even the decision of the Supreme Court of Appeal, sanitizing it by saying, no, Oscar has not been found guilty of murdering Riva. He murdered whoever was behind the door, but Riva was behind the door. And, you know, people are trying to kind of downplay the effect of the judgment of the Supreme Court of Appeal.
I read through the affidavit, and I read the Constitution. I grabbed my Constitution and I looked at it, and I find very little ground, if any, how the Constitutional Court will look at this case.
I would totally agree with you. I don't think there are any prospects that they'll even be granted leave to appeal, and even if they will be granted leave to appeal, I doubt that they'll be successful in that attempt.
We've spoken about the glare of television cameras at this trial, but this trial really has gripped South Africa and the world, and also taught a great deal of people about the law.
Yes, but on the downside of it, I don't know why, when it comes to Oscar Pistorius, so many mistakes are basically made. Because even if you look at his release and placement on correctional supervision, there was unnecessary drama around his placement. His placement ought to have happened when the parole board had initially said that. Dolus eventualis has been applied by the courts for years and years and years, and yet it had to take a trial of this magnitude for us to basically mess that up. Appeals at the Supreme Court of Appeal, convictions are set aside or convictions are imposed, and appeals fail routinely, and people are placed under arrest. Dalinyebo had to go back to the court in Umtata to basically apply for his bail to be extended. I mean, this happens under all circumstances, but when it comes to Oscar, all of a sudden, everything is a complicated legal matter, which it actually is not.
I want to go back to something else. Probably we should have discussed it earlier. The issue here is when people are being trained to shoot with a gun, I am told that one of the fundamentals when training to shoot with a gun is that you do not shoot through a door without knowing what is behind the door.
Well, we had the witness during the Pistorius trial who came and said that, you know, Oscar aced his assessments, he was competent, so he knew what he ought to have done with the firearm, and he did exactly the opposite.
Does it really matter? I looked at the discussion, the argument of the defense that he did not know it was Riva was behind the door. Does it really matter who was behind the door? I think you have answered that question, so probably you can...
Yes, it doesn't matter who was behind that door. It could have been anybody, for that matter.
Let us take this call from D. I don't know, D will tell us where he's going. Namibia. D, good afternoon. This is our regular caller from Namibia. Good afternoon and welcome to Rights and Recourse.
Thank you very much, Matthias. Good afternoon, everyone. I just think maybe the gentleman, he deserves prison. That's all. Because why it is taking too long if he killed somebody's daughter? He deserves the punishment. That's a fact. The law has been speculating everything very well. And the judge must take action. Why they have to keep delay everything? And that has not been happening so long. They are making even a pain to the family of the deceased. So they must analyze these things. It is a world news now that it's even paining the whole world. So they must analyze it.
Thank you, D. Thank you, D. D calling there from Namibia in Windhoek. D is making a point that was made by somebody I heard from the Prisoners Human Rights Association saying Oscar should just go to jail and just do the kind of things he was doing when he was in jail recently.
Well, there has to be finality to criminal cases, and this is what both the Supreme Court of Appeal and the Constitutional Court have said. And Dee is raising a valid point. The other thing that bothered me about the order that was issued by Judge Ledwaba is the fact that the defense wants bail pending an application for leave to appeal. That is fine. If leave is granted, then pending the appeal, I don't have a problem with that. But if leave is not granted, they still want bail extended, pending resentencing. So why then, if leave is not granted or the appeal is unsuccessful, then obviously a custodial sentence is going to be imposed, the minimum of which is 15 years, less the time already served in prison and in the community, and less whatever Judge Masipa will decide are substantial and compelling circumstances. So there's no justification for that. But I don't even think the state realized that they were extending that bail right up to the final minute where he would have no other avenue to basically say. And I don't know if you noticed that they snuck in the fact that in any event, when Oscar was sentenced, Judge Masipa conceded that it is culpable homicide bordering on dolus eventualis. So that sentence, in their minds, is an appropriate sentence. And I hope we are not going to have a sentence that does not befit the crime, if indeed he is unsuccessful in his appeal, because then the state will have to go back and appeal against the sentence which would be imposed by Judge Masipa, and we'll never ever see an end to the saga.
In response to what you and Dee are saying regarding the time wasting and the extension of the bail up to the last minute of the hearing, either of mitigation of aggravation, don't they say that the law has a long arm?
Well, not in those instances, because the courts have actually spoken. With appeals, actually, what is taken into account when you are granted bail pending appeal are the reasonable prospects of success. And I speak under correction, but I think I heard Judge Ledwaba saying the question here is whether or not the accused will stand trial. There's no trial. The trial is over. It's done. It's dusted.
Now, what if leave to appeal is not granted?
Yes.
If the Constitutional Court does not hear this case, what should happen on April the 18th?
On April the 18th, then possibly it might be postponed for more evaluations, the impact of incarceration on Oscar, for mitigation and aggravation. So we're possibly looking at the third quarter of next year.
Let us take this call from Thabo from the Eastern Cape. Thabo, good afternoon and welcome to Rights and Recourse.
Good afternoon. Thanks a lot. I must make this point, though. I'm very much impressed by the lady who was sitting next to you, to see a bold woman of herself.
I'm just as impressed.
Yes. Look, the judgment of the Supreme Court, for me, has actually rather revived the confidence that we can have in the justice system. Because, for example, I've always had a question. I've got no unknown qualifications on legal matters or anything. But I've always asked myself, why find somebody not guilty who has killed someone? On the very basis that you cannot shoot 4 bullets if you have got no intentions to kill. The number of bullets, and I wonder, why didn't this occur in the mind of the court, of the trial court? Why shoot 4 bullets when you have got no intention absolutely to kill? And if you look at how long the trial was and take into consideration how short the judgment was, it left a lot of questions as to why quite a number of things were left out in the judgment, or the consideration of fact towards the judgment. And I'd like the lady to actually comment on that.
Yeah. Thank you, Thabo. I think something Thabo raised, which I was going to raise, which is the Supreme Court of Appeal actually demonstrated to all of us that our law is in good hands.
Absolutely in good hands. And the issue that Thabo raises, and he raises pertinent points, not because I'm in total agreement with him, but he raises pertinent points. When I listened to the judgment. Remember, it was over 2 days. And Judge Masipa went to half the judgment, and for some funny or weird reason, she couldn't continue, and she postponed it to the next day. I immediately said on that day the state should start appealing, because this is going to be culpable homicide. But even her judgment, and I've said it repeatedly on various media platforms before, that another court could have found Oscar Pistorius not guilty, but applying the legal principles correctly. For example, there is an alternative judgment which could be written, and I'm not going to say anything so that they can get pointers on what to argue on. But she basically set out the legal principles incorrectly and then came to conclusions that did not speak to what she was actually saying, and the Supreme Court of Appeal also highlighted that. And to my mind, even as Judge Masipa read that judgment, I had a strange feeling that they had penned that judgment
Let's take this
together.
call. It's the last call we're taking from Nelly from Cape Town. Nelly, good afternoon and welcome to Rights and Recourse.
Good afternoon. I'm calling to say firstly, congratulations to the lady right next to you from the College of Law. My problem with this Oscar Pistorius trial that I would like everyone to take note of, every error that's been done on anything from the judgment at the court by Judge Masipa to now the judgment that was made by Judge Lidwaba, I think. Why is it that every error that is made by judges is being made by people of an African culture? I don't want to raise race or anything like that, but that's my concern. Would it now, this whole entire thing that is happening of people misjudging, all these errors that are occurring, is it not coming back to taint us and to prove us incompetent?
Well, thank you, Nelly. I think Judge Leach made it very clear earlier that the change of the sentence from culpable homicide to murder is not a reflection on Judge Masipa.
Well, Dumile, let me say this, and I thank Nelly for raising this very thorny issue. Yes, indeed, and you remember I've condemned all attacks against Judge Masipa. But in the same vein, I would ask myself why she would mess up in a trial of such a magnitude and international importance. But if we look at the Supreme Court of Appeal themselves, they've made big errors, legal errors, where the Constitutional Court, if you look at the Barnard case, for example, so, and appeals happen all the time in South Africa. They don't only happen in South Africa, they happen all over the world where there is a hierarchy of courts. For me, it was just the extent to which Judge Masipa got it wrong that bothers me. And then it comes back to the question of, with transformation of the judiciary, do judges, when they are seated in courts, and the accused person, for example, in this case, is a well-known, famous white person, do they have a problem stamping their authority and ruling as they ought to? And obviously this is just a question, and I've posed that question on Twitter myself, that with transformation, comes the confidence to say, I am going to stand my ground here and rule as I see fit.
Well, there seems to be no end to the Oscar Pistorius show. Looks like we are going to be back here again after the 18th of April, should the Constitutional Court not grant leave to appeal. This has been Rights and Recourse. This program is repeated at 5 on Monday morning. Do find us on Twitter and YouTube. From all of us here in the studio and the rest of the team, thank you to our guest and goodbye.
World makes it its business every evening to round up the leading local stories and international news to keep you informed all the time.
Make a date with Your World every evening for all the news headlines around the world to keep you abreast with knowledge.
Catch Your World for headlines across the world every Monday to Friday from 9 p.m, then Saturday and Sunday from 7 p.m.
SABC News. We report, contextualize and present news and current affairs honestly, fairly and fully. We consider it a duty to provide consistent, relevant, useful and top quality information and analysis. Our mission is to provide credible, accurate and interesting news programming, bringing news into everyone's homes in everyone's languages. Thank you, South Africa, for relying on SABC News for quality news output and for making us your #1 source of information. SABC News, Africa's news leader.
It's now exactly 1500 hours Central African time. A good afternoon once again and welcome to this Sunday edition of PM News live from Johannesburg with me, Obriel Mpofu. And joining me from the sports desk, El Shongwe. Some good news coming from the soccer front. South Africa now in the Olympic Games. Good stuff, isn't it?
They are, they made it by just, it was such a struggle, a great tournament overall. It gave them good experience, I believe. Lots of errors and lots of problems still to fix going forward into the Olympics. It won't be easy. But Coach Owen Dagama's Chargers really did their best yesterday. Plenty chances, they were unfortunate. But the problems at the back are really